Salam kebajikan and the best wishes to all of us. Distinguished Justice, respected representative of the ASEAN Law Association, esteemed speakers, colleagues, students, and all honorable participants, good afternoon and welcome. On behalf of Indonesia Jentera School of Law, it is my great honor and pleasure to welcome you to the Global Public Lecture Series entitled The Future of Cross-Border Restructuring Global Trend and the Changing Role of Court. We are truly privileged to gather today with distinguished experts and judicial leaders to discuss one of the most pressing developments in international insolvency and cross-border cooperation. To commence the formal session, it is my honor to invite our distinguished speakers to deliver their welcoming remarks. First, we are honored to welcome Dr. Arya Suyudi, SH LLM, Chair of Indonesia Jentera School of Law, to deliver his welcoming speech. Dr. Arya, please, the floor is yours.
Thank you very much, Distinguished Chair, ASEAN Law Association, Indonesia Chapter, Honorable Justice Samsul Ma'arif, Mr. Nicholas Moller, Principal Counsel, Asian Development Bank, our distinguished speakers, Mr. Scott Atkins, Consultant to the Asian Development Bank and former President Insol International. And I should also say Professor Scott Atkins. Don't forget that. Judge Jung from Seoul Bankruptcy Court, esteemed colleagues, members of the judiciary, respected practitioners, fellow academics, dear students, and honored guests. Good afternoon. On behalf of Indonesia Jentera School of Law, it is my great pleasure and honor to warmly welcome you all to our campus for this important public lecture on the future of the cross-border restructuring, global trends, and the change role of the court. We are deeply honored by the presence of such distinguished speakers and participants. Your attendance reflects the importance of the topic that we are discussing today and the shared commitment we all have towards strengthening the development of law in Indonesia and across ASEAN region. Allow me to first express our sincere appreciation to the ASEAN Law Association Indonesia chapter for this meaningful collaboration. It is both privilege and strategic partnership for Jentera School of Law. The ASEAN Law Association occupies a unique and vital position in our regional legal architecture. It brings together judges, legal practitioners, academics, government lawyers, and policymakers. It is not merely an association of professionals. It is a platform where institutional perspectives converge. The judiciary meets academy, practice meets policy, national experiences are enriched by regional dialogue. At Jentera, we see ourselves as aligned with this mission. Since its establishment, Indonesia Jentera School of Law has been committed to strengthening legal education and contributing to legal reform, particularly in the field of commercial and economic law. We believe that legal education must not only transmit doctrine, but also cultivate institutional awareness, comparative perspective, and reform-oriented thinking. Commercial law, including insolvency and restructuring, is not a peripheral field. It is central to economic resilience and governance. A country's ability to manage financial distress, preserve enterprise value, protects creditors fairly, and maintain confidence in its judicial system directly affect its economic stability and attractiveness as a place to invest and to do business. In today's globalized economy, these issues are no longer domestic matters alone. Corporations operate across jurisdictions. Assets, creditors, and contractual relationships spans multiple legal systems. Financial crises do not respect national boundaries. The legal response to economic distress must therefore be informed by comparative experience and international cooperation. This is precisely why today's topic is so timely and relevant. We are living in an era where jurisdiction would actively modernize their restructuring framework. The United States, United Kingdom, Singapore, and others have developed sophisticated rescue-oriented system. Courts have taken on increasingly proactive roles. Cross-border judicial cooperation has become more structured. At the same time, new challenges have emerged, including digital assets, complex corporate groups, and sovereign-related debt distress. For Indonesia and ASEAN, the question is not whether we are affected by this development. We clearly are. The development is how we should respond. At Jentera, we believe that thoughtful and principled economic law reform must be supported by these three pillars. First, strong academic foundation. Reform must be based on the careful analysis, comparative study, and empirical understanding. Second, institutional capacity. Courts, regulators, and practitioners must be equipped with the tools and knowledge necessary to implement reforms effectively. Third, dialogue between stakeholders. Reform cannot be driven by one institution alone. It requires collaboration between academia, judiciary, practitioners, and policymakers. In this regards, our collaboration with the ASEAN Law Association is natural and strategic. ALA represents the professional community that applies and shapes the law in practice. Jentera represents the academic community that studies, critiques, and help design legal frameworks. When these two communities work together, the result is more than just academic event. It becomes a forum for meaningful institutional exchange. We are particularly honored to host Mr. Scott Atkins, whose international experience in cross-border restructuring and leadership in global insolvency organization provides invaluable insights into how jurisdictions position themselves in an increasingly competitive restructuring landscape. We are equally privileged to hear from Judge Jung, whose judicial experience offers direct and practical perspective on how court should navigate complex insolvency cases. In discussion about restructuring, we often focus on legislation, but in reality, the effectiveness of a restructuring system depends significantly on the quality, independence, and sophistication of its judiciary. For our students, this lecture is an extraordinary opportunity. It is a chance for you to see how doctrine, policy, and judicial practice interact in real-world context. It is also a reminder that legal education must prepare them not only to understand statutes, but also engage with global development and institutional realities. For practitioners and judges in attendance, we hope this forum encourages reflection on how Indonesia and ASEAN can strengthen cross-border cooperation, enhance judicial capacity, and develop frameworks that are both competitive and principled. For policymakers, we hope this discussion contributes to the ongoing conversation about improving Indonesia's commercial law framework and ensuring that our legal system supports sustainable economic growth. We believe that strengthening insolvency and restructuring framework is not merely about technical efficiency, it's about protecting livelihood, preserving economic value, and maintaining public trust in the legal institution. In closing, I would like to once again thank the ASEAN Law Association Indonesia chapter for this partnership. We look forward to continued collaboration in future programs, research initiatives, and regional dialogues. To our distinguished speakers, thank you for sharing your knowledge and experience with us. To all participants, thank you for being part of this important conversation. May today's discussion be insightful, constructive, and inspiring for advancement of economic law reform in Indonesia and ASEAN. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam. Thank you, Dr. Arya, for your thoughtful remarks. And next, it is my privilege to invite Mr. Nicholas Moller, Principal Counsel at ASEAN Development Bank.
Thank you, and thank you, Dr. Arya, for the opening remarks. Very much in tune with what ADB is thinking and what ADB is planning to do. I guess I should talk a little bit about that. So for Asian Development Bank, we've had a long history in cooperating with Indonesia, and a lot of that has been with Dr. Arya in various different things before we turned our attention to the insolvency law. So there was a little matter of the omnibus law and the business licensing chapter of that we helped look at for a couple of years. But since then, we've really been looking at trying to do something on insolvency law reform in Indonesia. So it's been great to be able to try and do that and develop the relationships that we have now with Dr. Arya and Jentera, with hopefully with ASEAN Law Association as well, and of course the Supreme Court, with whom we meet reasonably regularly on these matters. So we very much appreciate that, and look forward to doing more work there. Just for those that less familiar with what we do in law reform at ADB, so in the legal team, there is a team called the Law and Policy Reform Team. And if you choose to, you can volunteer to be part of a law reform team. So I've led one that is focused entirely on insolvency law for roughly almost 10 years now. Actually, with Scott and his firm, we started off in Myanmar, and we got through to eventual legislative approval of the 2020 Myanmar insolvency law with associated regulations, and which did involve and include the cross-border model law as well. Since then, we are continuing to work on law reform and insolvency in countries as diverse as Bhutan and Armenia. We've started already in further East Asia, in Kyrgyzstan and Tajikistan. And just this year, we've got new requests to help out with Vietnam on their new law that just came through a couple of weeks ago to help them put that into practice. We've also got a request from Cambodia as well to help them with a new law. They have a law that's about as old as the Indonesian one. And a couple of other small islands, Pacific states are thinking about engaging ADB as well. So I just wanted to give you that bit of background about ADB. I hope everyone enjoys the presentations today, and look forward to talking to you during the course of this afternoon. Thank you.
Thank you, Mr. Moller. Next, it's my privilege to invite Honor Justice Syamsul Ma'arif, SH LLM PhD, ASEAN Law Association Indonesian Chapter, to deliver his welcoming speech.
Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera untuk kita semua. Ladies and gentlemen, the honorable speakers and distinguished attendees of the Global Public Lecture Series. Very good afternoon, and it's an honor for me to provide opening remarks for the inaugural Global Public Lecture Series jointly held by ASEAN Law Association Chapter Indonesia and Indonesia Jentera School of Law, and of course the ASEAN Development Bank. I would like to thank all parties that have made this event possible. Today is a special event as it is held during the holy month of Ramadan. I commend my committee for organizing these lectures and the joint break fasting, and may it be a token for our Indonesian hospitality to our esteemed guest speaker. My sincere appreciation for our guest speaker, Professor Scott Atkins. Thank you very much. And Judge Jung, thank you very much. And what I know is that both of the speaker actually the expertise who are familiar with the ASEAN Pacific region. And it is an honor for us to hear from your leading insight on global trends and the structuring and the role court play in it. Thank you to Mr. Ari Ansuyudi, Chair of the Indonesia Jentera, and his team for preparing this event and hosting us in your premises. My sincere gratitude to ASEAN Development Bank, represented by Mr. Nicholas Muller. I met him many times, who has facilitated also today's lecture by hosting our esteemed speakers in Indonesia. I'm also gratitude for the participation of each and every members of the audience, especially to the university students present today's audience. Know that you are the future of this country and its legal professions. Many of the members of ALA Indonesia actually also present at this event, and I would like to thank also to all our members, the ALA members of Indonesia. First, I would like also provide a bit background on the ASEAN Law Association. Dr. Arya also a bit mentioned, but I like to add a small thing. ALA is a non-NGO organization that was established to promote the advancement of regional legal integration through cross-border legal cooperations among ASEAN member states, and among others through the harmonization of its law. ALA is very well represented by its members, consisting of members of the judiciary, law enforcement officers, and legal practitioners and academicians. In this regard, ALA is also able to do what all standalone institutions they are not able to do. It has the ability to unite these different professions together under one organization to foster collaborations and a common sense of purpose to advance the rule of law through initiatives such as today's public lecture. In today's audience, we are able to see representative from judiciary, practitioner, attorney from Peradi, Congress Advocate Indonesia, in addition to Receiver and Administration Association. They also come today. And having this comprehensive sets of representative presence provide me the confidence that we, as members of the legal professions, can join our hands together and collaborative for greater causes. Ladies and gentlemen, the 11 ASEAN member states form one world most dynamic economic blocks. It boasts about 700 million, a strong population who aggregately contribute to the continent gross domestic product, which is on track to rank as the world's fourth largest economy by 2050. And I see IDB also know that. Yeah? And at the same time, the region is poised to attract over 100 billion US dollar in a planned infrastructure development project, and not to mention other sectors that has contributed to the economy. And to achieve continuous progress in developing our countries, we must provide legal certainty as a pillar of trust for our development partner. Resolving insolvency remains a crucial indicator of the ease of doing business framework, which in turn is used by multilateral development agencies such as the ASEAN Development Bank to assess the business environment in emerging economies like Indonesia. So today's discussion shall explore deeper on the role of the court as stakeholders in restructuring and insolvency process, as well as its interaction with other stakeholders, such as restructuring insolvency professionals. I would like to conclude my address by thanking everyone present in today's discussion. May our reflections from today shall be a valuable input for Indonesian legal framework, especially as Indonesians seek to modernize its restructuring and insolvency laws. And I trust that today's discussion shall be the first of many events we will host in contributing toward Indonesia and ASEAN legal advancement. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam. Thank you, Your Honor. But you don't have to leave first, Your Honor. Okay. I will invite back Dr. Arya Suyudi and Honor Justice Syamsul Ma'arif to come forward and join for the signing ceremony. We will now proceed the signing of the Memorandum of Understanding between Indonesia Jentera School of Law and the ASEAN Law Association Indonesian Chapter to support the implementation of the 3 pillars of higher education. Okay, hold up. Now we proceed with the symbolic handing over flag. Okay, may we also invite our distinguished guests to remain for a group photo session. Your Honor Igusti Agung Samanata, Your Honor Cerah Bangun, Your Honor Emi Marni Mustafa, Your Honor Adriani Nurdin, Your Honor Lydia Sasando Parapat, Mr. Suwandi Halim, Mr. Nicholas Moller, Dr. Andes Normin S. Pakpahan. Thank you, distinguished leaders. You may now return to your seat. We now arrive at the highlight of today's program, the lecture session. This session will be moderated by Dr. Andes Normin S. Pakpahan, SH-MBA, Vice Chair of the ASEAN Law Association. And I would like to invite Dr. Andes Normin S. Pakpahan to take the stage, introducing our amazing speakers and moderate the session. Please, Dr. Andes Normin, the floor is yours.
Good afternoon. Peace be with you all. Assalamualaikum warahmatullahi wabarakatuh. Well, my pronunciation, maybe it's not correct, but the meaning is peace to you all. All right. Well, this afternoon, we have a very unique situation whereby the moderator is a retired person, but we are quite fortunate enough to have two distinguished speakers so that they can share their knowledge with us. And I'm very happy to invite Professor Atkins, and Madam Jung. Both of them are very distinguished in this field. And before I pass on the microphone to the two distinguished speakers, I would like to share a little bit of my notes on insolvencies. Insolvencies, as I understand it correctly, is very important. Why? Because being an economist myself, it's my interest to see to it that all economic players will sustain in doing their work and jobs. And why they're very important? Because they contribute a lot to the economy of this country, any country. Any players in the marketplace is very important to sustain their activities. However, as life, we have hills, we have valleys, right? Ups and downs in their life. And also the business people also face the ups and downs in their business. They don't like it, of course. What they do like is growth. But unfortunately, as the nature itself says, sometimes we have to walk a narrow pathways, winding roads, hills and valleys, okay? Now, if I compare that to the legal systems is a system to accommodate all the economic players to sustain their activities. Actually, that's the philosophy seen from the standpoint of an economist. What is the meaning of law, commercial law on that? However, on the other hand, there is another school of thought saying that law must preserve rights and obligations. In business communities, rights and obligations is an equation. Sometimes, for the standpoint of economists, an equation must reach a balance. We call it general equilibrium, okay? But sometimes, in order to achieve the general equilibriums, we have to go through all this process of high and lows, hills and valleys. And sometimes when you stumble, we just cannot stand up by ourselves. Somebody must help you. The same situation also works for business players. And law plays a dominant role to provide a good environment for them to do so. And insolvency, from my standpoint, has a role to do that, to help the business people to keep on working to sustain their activities. Now, this afternoon, we have the opportunity to listen to the two experts here. First of all, Professor Atkins, I think I will give a floor first to you. You can share with us what is meant by insolvency and to what extent that we can use insolvency to become a language. I think this is a good comparison. If I want to do business deals with an Americans, right, I have to speak English, okay? Because it's my interest to do business in the United States or in England or anywhere. First of all, I would like to find what is the common playing field. One important variable in common playing field is a language in this case, right? Now in business, one common playing field is law, okay? So if we look at that, I think the students must try to understand that law must be seen from different angles so that we can understand why sometimes the rules is not applicable to a certain situation. On the other hand, also, the economists, the business players must try to understand how the other partners will look at it. And if we are at the low point, we are at the bottom of the valley, okay, then we need somebody, we need an environment for us to keep on sustain our activities. So, my fellow friends, dear students, my fellow ALA members, this afternoon we have this opportunity to listen to the two experts we have here, and so that we can learn a lot from them, and also to give inputs to the government of Indonesia, how to handle insolvency in the global situation. So the future of cross-border restructuring is very important for us to understand. Now, with further ado, Professor Atkins, I give the floor to you. Let's big a big welcome to Professor Atkins.
Well, thank you very much for that incredibly warm welcome. We feel very honoured to be here, and you'll hear from the judge shortly as well. But we've been speaking together for the past 2 days, and this is a very warm reception and a great honour for us to be here in the law school of Professor Arya, who I think is in the room. Oh, here he is, right on cue. And none of this would have happened without his hard work behind the scenes. So we're very grateful for the work of the professor. You're very lucky to have him here at the law school. And of course, congratulations to ASEAN as well. And thank you for the support. And of course, the Asian Development Bank. Nothing happens for us without the ADB support. And Mr. Moller is here. And as you've heard, he's been a critical part of what has happened for law reform across Asia very broadly over the past getting closer to 15 years, really. So I'm going to talk about two things today. One is about insolvency, and I'm so grateful for the introduction because some of the work for me has already been undertaken, and that is, why does insolvency law matter? And much of this really is directed to the student cohort who are here, because often people think that insolvency law is really only to fix up companies that are not functioning properly. But in fact, as you've just heard from our colleague who shared with me and with the judge his broad experience before we started our session today, it's critically interconnected with economic growth and economic success. So while in the past, insolvency law might have been put in its own category of law that deals with companies that have ceased to perform financially or are otherwise suffering some shock to them, which is causing them to potentially collapse or indeed to collapse. The truth of the matter is that insolvency law's most powerful contribution is to support economic growth and economic development. Sometimes at this point, a student's hand will go up and say, I know the answer and the reason why that is so. But in the interest of time, because this afternoon I'm catching a plane back to my hometown of Sydney, because I'm in court tomorrow resisting a winding up application for an insolvent company. But the answer really to this proposition is quite simple. Insolvency law, when it's operating most efficiently and most effectively, helps to recycle capital in the economy. It takes it from underperforming situations. It unlocks it from companies that might have failed or that have seized up. And it helps to move that capital to those parts of the economy that are productive or that have the capacity or the need or the desire for more capital. So that's really what insolvency law does. And so when we have discussions about modernising insolvency law, as is happening in Indonesia and indeed has been happening for some years, and I've been involved in discussions around insolvency law reform in Indonesia going back at least 8 years. I remember my very first discussion was with the judiciary. But the reason why we focus on modernising insolvency law reform is not because we want yet another law, and it's not because we simply want to tinker at the edges. It's because to achieve the economic growth aspirations, countries need to ensure that they have the best tools available in the insolvency and restructuring toolkit to achieve the very outcome that I've been talking about. Now, we have touched upon in our previous sessions across all of yesterday, in our discussions this morning at the Supreme Court, and indeed with the Chief Justice, who we had the great honour and privilege of meeting just before lunch, we've been discussing this critical interconnection between economic growth and insolvency law. And we've been discussing it in the context of the 2045 economic plan of Indonesia. So the aspiration in this country is clear. And one part of that, and I'd like to then link this to the second part of my remarks, is attracting foreign investment and conversely ensuring that we have a system in place so that if there's a cross-border insolvency event, and we'll talk a bit about that, then we've got the best tools available for practitioners, for the courts, and for investors and business owners and operators to be able to deal with that situation. So let's shift from those general principles about why insolvency law matters and move across to why is cross-border insolvency something that we should be discussing, and why should we enthusiastically move toward adopting the the model law on cross-border insolvency. The introductory remarks touched upon the complexity of the global situation, and you heard that also from Aria, you heard it from the judge, and you heard it from Nick Moller as well. The reality is that when we look at the economic construct in Indonesia, as it is the case in South Korea, where the judge is from, as it is the case in Australia, and really across most of the world, business operates globally. It pays no respects to borders, as you heard Aria say so eloquently in his remarks. So we need a system that similarly responds when a company operating across multiple countries fails, and that does happen. And if we just think about the globally significant events occurring right now, there is no question that there will be the collapse of a business or many businesses as a result of these unexpected, quite extreme impacts. If you just think about what you're reading in the press about these impacts, it's quite obvious that the aviation industry and the shipping industry and soon the tourism industry will be very significantly impacted. And many of these businesses will not have undertaken pre-planning or have built into their business plans any expectation of the impact, the quite existential impact that's been inflicted upon them as a consequence of these global events. So while that's all a bit doom and gloom, what it really means is that we need systems in place ready to react so that if a company operating across multiple countries collapses, we can at least do our bit here in Indonesia, as we can in other countries where the model law is in place, to be able to swiftly respond to that insolvency situation. I think we also probably accept universally that in insolvency situations, we need two critical ingredients, and we see this in the system here in Indonesia. We need efficiency and we need low-cost solutions. Now, when I talk about low-cost solutions, that's tied up with efficiency, but I've used efficiency deliberately in terms of process, in terms of the court process, the way that practitioners undertake their work, the way that businesses respond. We need low cost because we know in an insolvency situation there are limited resources to go around, and we need to ensure that we're spending as little money as possible to achieve a reorganisation or to manage the insolvency process, to maximise the available capital, or in some instances to maximise the return to creditors if the business is to be wound up. So we have this instrument called the UNCITRAL Model Law on Cross-Border Insolvency. UNCITRAL, the United Nations Commission on International Trade Law, is part of the United Nations, and it's focused on, as its name suggests, trade law, and in particular harmonising trade law across the United Nations member countries. And in the mid-1990s, Working Group number 5 of UNCITRAL was established, and Working Group number 5 is focused on cross-border insolvency and cross-border insolvency systems and processes. And in May 1997, after a lot of work from many UN representative countries working in this particular Working Group 5, and you can find all of these resources, in fact, on the UNCITRAL website. It's rich with resources. But the Working Group recommended to the United Nations in General Assembly that there be the adoption of a model law on cross-border insolvency. And that's exactly what was recommended on the 30th of May, 1997 by the UN General Assembly. And since then, almost 70 countries have adopted the model law, and there is discussion underway right now and some incredibly effective and valuable work undertaken here in Indonesia to support and hopefully ultimately recommend and achieve the adoption of the model law here as well. Your near neighbour Malaysia adopted the model law last year. Ahead of that, a little bit, also your near neighbour Singapore adopted the model law in 2018. Korea has the model law, as does Australia. We adopted it in 2008. And there are many other countries in the region thinking very carefully right now about adopting the model law as well. And why are they doing this, or why has this happened? Well, for the very obvious reasons that I've already touched upon. We need a framework to support courts and practitioners and businesses to respond effectively and also very efficiently when there are multi-jurisdictional business failings. So I'm going to talk very briefly about how the model law operates. The judge is going to give you a very fascinating perspective of how judges approach the model law. And it's been such a privilege having these discussions with the judge, because what you'll hear is that Korea has embraced the model law and has built a court system around it to give very effective market-leading responses. And so it's a fantastic illustration of the opportunity that lies ahead for Indonesia. So at the heart of it today, I change it each time in each presentation I do. I usually choose a country and I choose a business. And I think, I'm not sure what we'll do today. I think today I'll choose France. Let's have France for a change. I don't think I've used France as an example before. So we'll think about a big French company. It's probably in the business of making croissants and shipping them around the world. And as you would expect, French croissants are probably in high demand. It's hard to imagine they would ever go out of business, but let's assume there's been some shortage of a particular ingredient in their supply chain. So the French company enters into an insolvency process and it files in the main commercial court in Paris. And of course, these croissants are very famous here in Jakarta. And regrettably, the business here closes as well. And they're also exporting their croissants across all of Asia. Not in Australia, because we do have some of the best croissants in the world, but that's a different story. You can look them up on Instagram. So the French bankruptcy representatives come to Indonesia. By now, we've adopted the model law, and they approach the court and they make an application to the court for recognition of the French insolvency process. And they ask the court here to confer powers on those French representatives so that they can take control of the croissant businesses that are here in Jakarta and maybe elsewhere in Indonesia. And at the heart of it, that really is what the model law is designed to do. It's to provide a framework that enables the court to facilitate that recognition of that foreign insolvency process and to confer appropriate powers on the representatives locally, usually together with a prominent and qualified, capable local practitioner or financial advisor. Mr. Ricardo is here, so I would imagine he will be appointed locally in most of these cases, especially the croissant case. And then using whatever powers are given locally, the job of those representatives is to make sure that they do exactly what would otherwise happen here in any domestic insolvency, which is either to restructure the business and hope that it continues, or wind the business up, liquidate the assets and make a distribution centrally back to creditors. Now, you think about that situation if we didn't have the model law, how would the French insolvency representatives access the courts here in Jakarta? How long would that take? Meanwhile, what would be happening to the business that is here? Who's controlling that business? Who's protecting that asset and making sure that it's not somehow the subject of local enforcement action? How long would it take for the court to receive that application, to consider all of the issues and ultimately make a judgment? So you only need to think about it in the reverse to understand why it would be so beneficial in the context of international insolvencies to have this facilitative model law here. So that's why nearly 70 other countries have adopted the model law. There are many different nuances in the way that it operates and in the interests of ensuring that the judge also has an opportunity to discuss today. I'm not going to go into that detail. You have Professor Aria here, who is a deep expert, and Mr. Ricardo as well. And once we depart, they'll certainly be able to help answer any questions that you have. But if we track back a little bit in time, leave my croissant example aside for the moment, when Lehman Brothers filed for Chapter 11 bankruptcy in the United States on the 8th of September 2008, we were very fortunate at that point that many countries had adopted the model law, including the United States under its Chapter 15 bankruptcy recognition process, the United Kingdom under its Insolvency Act, Germany, where another very substantial part of Lehman Brothers' estate was, and on the list of countries goes. Australia had fortunately just adopted model law. Singapore had not at that point. But in any event, when we had that global systemic collapse of an investment bank, we were very lucky that the model law already existed and courts around the world were able to very efficiently respond. Now, not every court that had a Lehman Brothers administration before it had the model law in place at that point. And so those courts had to navigate the issues, focusing primarily on the domestic insolvency first. But in the end, Lehman Brothers was a very well coordinated, very successful global workout. And the return to creditors was very significant because the estate was able to be administered with great efficiency in a very timely manner. And indeed, one aspect of it that in these discussions so far, the judge and I have not touched upon, but increasingly we see it come into the operation of cross-border insolvencies, and that is mediation. So not only did we have the model law operating, but we also had a much more enlightened and contemporary approach to the power of mediation to help resolve some of the disputes. And I've now forgotten the precise statistic, but it's something in the order of 97 Lehman Brothers cases were referred off to mediation, and of that, something like 72 of them were resolved through that process. So that was also working in tandem with the model law. And I know the focus in these discussions over the past 2 days has not been around mediation, but it's a timely reminder and a self-reminder that mediation is another adjunct to a contemporary and effective insolvency law. So turning back to the croissant example, I hope that helps appreciate at the heart of it what the model law is. The instrument itself is very simple. It's only 35 articles in the original 1997 text that you can find when you go to the UNSA trial website and have a look at the materials. And the idea is that those principles are imported into domestic law. Our recommendation always is to try and bring them in as a standalone text, if at all possible, rather than dispersing them and making it hard for the practitioners to find the critical provisions. It makes it much easier than to harmonise the way that the cross-border recognition processes operate around the world if we're working off the original core principles as closely as we possibly can. So I do hope that the hard work here continues. I urge those that have a role in influencing that process or who are interested in continuing a discussion about why this is so important from an economic growth perspective, a business perspective, and a legal perspective to engage in the debate and the discussion. And let me address head on, and this will probably bring me to the end of my remarks, but let me address head on what are the two reasons why typically it is said that the model law is a bad idea and a country should not adopt it. And I'm saying two, because in all of the discussions that I've undertaken over the past 10 to 15 years or longer about the model law, I've only ever had two put to me, and I think that's about it. But number one is that it results in foreign law coming into the country, and we would allow foreign influence in that way to come in on the back of cross-border insolvencies. Well, that doesn't happen, and there are two reasons why that does not happen. The first is the model law is simply a framework that facilitates recognition. It does not contain substantive law, and it does not in any way impact upon or influence or shape domestic law. That remains a matter for your legislative processes. The second and more comforting reason is that the judges are in control of the process. So in every country where the model law has been adopted, it is only the courts of that country that can regulate the recognition and the operation of a cross-border insolvency once recognition is given. There's simply no other way that it works. Sure, you can have out-of-court restructurings and out-of-court processes, but that doesn't give you the same level of recognition that you have under the model law. So that's the first category. So we have no need to be concerned about foreign influence or foreign law coming into the country. The second concern often expressed is that it will take work away from local professionals because you'll have insolvencies being conducted by professionals from other countries. And that also simply isn't the case. And it's not what has happened in any country where the model law has been adopted. And again, there are two reasons for that. The first is that one primary reason I should say that they're connected. The primary reason is that when foreign insolvencies are recognised here, sure, powers are going to be conferred on the representatives of the foreign bankruptcy to do things here. But courts like to have a connection jurisdictionally to anyone who has been provided with relief. And so the convention that we see across the world is that usually a requirement will be that a local practitioner is appointed alongside of the foreign representative to facilitate, assist, and help the foreign representative navigate the local requirements of the insolvency process and the laws domestically. Because, of course, things still need to happen in the shadow of the local law in that sense. So what we have found is rather than local practitioners being displaced from having that opportunity, instead, the potential work available to them opens up and expands. And they also find that they're building richer, deeper and broader professional networks and connections across the world, which is also beneficial for the economic growth of the country, because they're suddenly engaging with and liaising with professionals well beyond the domestic borders of the country. If anyone ever thinks of any other reason why the model law is a bad thing, please do let me know. But so far, I've only ever heard of those two, and I'm always very happy to have a debate about those matters. So that's a broad survey of both why insolvency law matters, and I hope for the students in the room that they continue to study insolvency law and send all of their hard questions to Professor Aria. And also hopefully gives you an insight as to why the model law on cross-border insolvency, which is now in its 29th year of operations since having been recommended for adoption by UNCITRAL, is absolutely an appropriate instrument for Indonesia to adopt as well. So thank you so much for listening to my remarks. I do have this little timing issue, so if I have to disappear at some point, please don't take any offense from that. I'm juggling tomorrow, as I shared with my colleagues in the car on the way here, what might look on the face of it like a simple winding up petition, which is not unlike a winding up that you would have in your jurisdiction. But there are 35 advocates appearing tomorrow, either supporting and proposing the winding up or trying to resist it. So I'm in the resistors camp for once. So I regrettably, on this occasion, will need to fly home overnight. So I'm just watching the time. But thank you so much. And it's been a very great honour and privilege to be able to come here today and also to visit the law school. And I do wish Aria all the very best with this law school. It's very special for us to be here this afternoon in the presence of this wonderful group of people. Thank you very much.
Wow. Thank you very much, Professor Atkins. If I can sum up, I think, the key is, number one, if we know the so-called legal certainty and legal predictability, insolvency, I think, will give some kind of a means for the business people to really understand what is meant legal predictability and legal certainty from the framework of business activities. Number two, for Indonesia to really play a major role in the global market, then Indonesia must open the border to speak to the other business communities. When it comes to insolvency, then we have to rely upon a certain ways and means acceptable to all parties. And I think it's very rewarding for us, especially for the students, that the United Nations has already provided some kind of a legal means to do that, which is called UNCITRAL. I think the big issue now for this country is how we are going to address the issue of globalization, whereby Indonesia will take part in it, and what happened if there is an insolvency cases involving the Indonesian companies in the international market. We do not have the environment for the legal environment for that yet. So I think later on in the discussion, maybe you can share your thought. How was your conversations with our colleagues from the Ministry of Justice in trying to adopt the Central and maybe reform the so-called Undang-Undang Kepailitan? And to what extent our Undang-Undang Kepailitan bankruptcy law will be adjusted to the substance of Uncentral. I think now let's hear from Madam Yu, how Korea addressed the Uncentral. I mean, how Korea adopt the Uncentral and how the courts, address the situation of that. Without further ado, Madam Yu. Yeah.
Thank you, Honorable Moderator. If the people could allow me to stand there and give the presentation, because would it be okay if I stand here in order to see the TV screen for it? Yes, thank you. Hello, everyone. Nice to meet you. Hello. And I learned some language that is used here. Please check if I'm correct. Assalamualaikum. Selamat, selamat sore. Selamat sore. Barakallahu fik. Alhamdulillah. Know that this is the season of Ramadan here in Indonesia, and I have some friends during Ramadan. So I wanted to express my gratitude and respect to the Indonesia. Honorable judges, professors, students, professionals, and colleagues, it is a huge honor to be here with you today. I have practiced these greetings as a sign of my deep respect. Seeing the intense focus in the eyes of so many participants today, I feel my own passion for this subject truly igniting. Thank you very much.
Check. Would you like? Nothing. Would you like? Use this.
Ah, thank you. I will hold it with me. This will be okay. Do you hear me well? Ah, yeah. Wait, something higher. Okay. Now it will be fine. Thank you very much. I love your reactions and passions. Thank you. So I brought some photos of my court. This means that the Seoul Bankruptcy Court was officially established not as a commercial court of several relevant fields, but as an independent, insolvency-only oriented court. Regarding our location, you can see our geographical position within the Republic of Korea, that's South Korea, and specifically within the heart of Seoul on the maps provided here. Now, looking at the traditional Korean themes in my presentation today, you might imagine that the Seoul Bankruptcy Court itself is housed in a traditional architecture building. However, as you can see in the main photos on the screen, our court is actually located in these modern facilities. Next slide, please. The motto of the Seoul Bankruptcy Court, which you see on the slide, is this: a stepping stone to a new start. By being physically and symbolically closer to those in need, we are reaffirming our commitment to serving as a reliable foundation for their financial recovery. Next slide, please. Thank you. Leading up to the official opening of the Seoul Bankruptcy Court, our journey into cross-border insolvency frameworks began much earlier. In 2006, the Republic of Korea formally adopted the ancestral model law on cross-border insolvency. The Republic of Korea enacted, this is the name of the legislation, the law, the Debtor Rehabilitation and Bankruptcy Act, which is called DRBA, in 2006 to incorporate the ancestral model law in its national law. This legislation introduced the new Chapter 5. The chapter's name is Chapter 5 on cross-border insolvency, effectively abolishing the extreme territorialism of our former insolvency laws. The ancestral model law on cross-border insolvency. Do you guys know what that contains in the law? Or do you guys need a brief introduction? I will go with a brief introduction of the model law. Was formulated in May 1997, established the framework to overcome the limitations of territorialism. It allows the effects of insolvency proceedings initiated in one jurisdiction to be recognized in others. In particular, the model law treats proceedings commenced in the state where the debtor has its center of main interest, which is called KOMI, and as so-called foreign main proceedings. This status enables such proceedings to be granted powerful forms of relief, such as an automatic stay. So the model law allows automatic stay, even in jurisdictions outside the lex fori concursus, which means the law of the forum where the insolvency case is pending. In line with these international legislative trends, the Republic of Korea enacted that I called DRBA in 2006. This legislation introduced a new Chapter 5, effectively abolishing the extreme territorialism of our formal insolvency laws. Korea transitioned toward a framework of modified universalism, from territorialism to modified universalism. Where it may be difficult to say that the DRBA adopted the ancestral model law in its entirety at that time, the Seoul Bankruptcy Court has been proactively filling that gap. Through our comprehensive procedural guidelines and the stable execution of cross-border judicial cooperation, we ensure that the spirit of the model law is fully realized in practice. The procedural guidelines, let me tell you what that means, because it is going to appear several times in the later part of this presentation.
Those are a set of detailed judicial protocols that supplement the DRBA, while the law provides the statutory framework. These guidelines offer concrete instructions and standards for judges and legal practitioners on how to handle cases in court. They are crucial because they allow us to promptly reflect global standards within our existing legal structure, ensuring speed, consistency, and predictability. As you can see on the screen, the primary evolution of the Seoul Bankruptcy Court's practice has unfolded rapidly from our opening in 2017 through 2018 and 2020, leading up to the present day. Next slide, please. I believe you may be curious about the current status of the Seoul Bankruptcy Court, particularly in terms of the scale and volume of the cases we handle. To give you a sense of our current scale, last year, our court handled a highly demanding docket. We recorded 477 corporate rehabilitation filings, marking a significant 36% increase compared to 2024. And corporate bankruptcies stood at 1,074, a considerable 24% increase from the previous year. And then individual rehabilitation filings reached 28,367, also representing a notable 13% rise. And then individual bankruptcies remained relatively stable at 8,615 filings, a minimum 1% increase. These figures underscore not only the economic realities we face, but also the sheer volume of the distressed assets and complex restructuring scenarios our specialized court navigates daily. So considering the latest development, the Republic of Korea, in 2023, there were 2 more insolvency-only specialized courts in the nation. And then about 3 days ago, new 3 insolvency-only oriented courts opened in the nation. So in sum, there are 6 insolvency-only oriented courts in the nation. And then turning to the next slide, please. Here comes our case handling practice. Let me tell you this first of all. Cases concerning recognition of and relief, that is called assistance in our law, DBRA, relating to foreign insolvency proceedings are placed under the exclusive jurisdiction of the Seoul Bankruptcy Court, under Article 630 of DRBA, especially under the 3 judges panel, which is 3 judges tribunal. Meanwhile, a foreign representative may apply to the Seoul Bankruptcy Court, where the debtor has their place of business, office, or domicile in the Republic of Korea under Article 631. Next slide, please. Cross-border insolvency cases in Korean law are governed by Chapter 5, as I told you before, of the DRBA. I'm going to tell you about the changes, a few changes we made when adopting the UNCITRAL model law. The DRBA recognizes the general concept of foreign insolvency proceedings. However, it does not explicitly distinguish between foreign main proceedings and foreign non-main proceedings. In this regard, the DRBA stops short of fully adopting the UNCITRAL model law. For instance, even for what would be considered a main proceeding, substantive legal effects are not granted automatically upon recognition. Instead, they require a separate and independent relief order, in addition to the recognition order. Furthermore, our framework contains provisions similar to Japan's Act, which is equivalent or similar to the DRBA, such as the appointment of a cross-border insolvency representative who holds the authority to dispose of domestic assets independently of the foreign representative. In essence, while the DRBA adopts a recognition system of the model law, it simultaneously maintains a dual-track structure of recognition and relief, much like the Japanese model. Next slide, please. The procedural mechanics are straightforward and highly structured. I'm worried the letters might be too small to see, and I'm going to tell you briefly how this flow chart goes. From the top, let me say a foreign representative applies to our court for recognition under Article 631. Upon application, the court may grant provisional relief under Article 635. Once the requirements are met, formal recognition is granted under Articles 632 and 633. Following recognition, the foreign representative can apply for specific relief under Article 636. When granting is relief upon recognition, our court has a versatile toolkit to protect the debtor's assets and the interests of creditors, including stay of actions or administrative proceedings, stay of execution proceedings, prohibition of repayment or disposal of properties, and appointment of cross-border insolvency practitioner, or any other relief to protect creditors. We strictly adhere to statutory grounds for dismissal outlined in Articles 632 and 636 to ensure due process. Next slide, please. Furthermore, there is a specific section, 641, that is Article 641, that explicitly mandates cooperation, that says cooperation, when there are concurrent or parallel proceedings involving the sole bankruptcy court and the foreign court and a foreign representative. For cross-border insolvency cases, specifically those involving the recognition of and relief to foreign insolvency proceedings, the sole bankruptcy court has handled a cumulative total of 34 cases since its establishment as of December last year. The sole bankruptcy court has previously issued decisions granting recognition of and relief to foreign insolvency proceedings conducted in jurisdictions including the United States, the United Kingdom, Australia, the Netherlands, Hong Kong, Japan, and the Philippines. On January 2nd this year, the court has, for the first time, granted recognition and relief to foreign insolvency proceedings conducted before a Russian court. Next slide, please. So here are three main cases handled under Chapter 5 of the DRBA and procedural guideline. We have successfully applied those principles in several notable matters. For instance, one example is the Hanjin shipping rehabilitation case. The sole bankruptcy court conducted a joint conference call with the U.S. Bankruptcy Court for the District of New Jersey on January 18, 2017. As a direct result of this judicial communication, our court successfully secured the remittance of sale proceeds from the liquidation of Hanjin Shipping subsidiary shares, which were being held under the U.S. jurisdiction. In the matter of the second one, Mr. and Mrs. Kang case, a Chapter 11 case as main insolvency proceedings initiated in the U.S. Bankruptcy Court for the Eastern District of Virginia. After obtaining a recognition order from the sole bankruptcy court and being appointed as the cross-border and foreign insolvency representative, the foreign representative sought permission to remit the proceeds from the sale of the debtor's Korean real estate to the United States. And to process this request, the Court of the United States issued an order establishing protocol for communication with the sole bankruptcy court. This is the name of the order by the United States Court on October 30, 2017, followed by a reciprocal cooperation from our court on November 8, 2017. Under Article 641 of the DRBA, the two courts engaged in an active exchange of views until January 2018, specifically addressing whether Korean creditors had been afforded adequate notice and opportunity to participate in the United States proceedings. Upon confirming that the rights of domestic creditors were sufficiently protected and that the remittance would not violate public policy, the Seoul Bankruptcy Court ultimately authorized the transfer of the sale proceeds to the EDVA on January 18, 2018. And the last case is involved with Lehman Brothers Europe, and it is the communication with the High Court of Justice of England and Wales. And this was the similar one with the other cases. Next slide, please. So we saw the basic legal framework under the law and some of the procedural guidelines. And we are jumping to the chapter of cooperation and coordination practice. Executing something under this legal framework, it is a different one, right? Executing it effectively across different legal cultures and time zones is another. This brings me to our specific cooperation protocols, and that will be shown in the next slide. So this is the basic structure of the procedural guidelines that I mentioned to you earlier in my presentation. So in September 2017, the Seoul Bankruptcy Court enacted procedural guideline number 504, titled Guidelines for Communication and Cooperation Between Courts in Cross-Border Insolvency Matters. To align with global best practices, we revised, updated this guideline in July 2018 to incorporate the Judicial Insolvency Network, or JIN, guidelines. Let me tell you about this JIN, because I think some of you may have heard of it, but others may have not. The Judicial Insolvency Network, which is called JIN, is a specialized global network of insolvency judges from all over the world and from the jurisdictions worldwide. Established in 2016, its primary mission is to enhance judicial cooperation and communication in cross-border insolvency cases. Rather than focusing on abstract theories, the JIN focuses on practical solutions. Its most significant contribution is the JIN guidelines, which provide a standardized framework for how courts in different countries should communicate and coordinate with one another in real time without any procedural delay and dynamic direct communication for a synchronized action. Joining such a network allows the judiciary to stay at the forefront of international best practices. It ensures that our courts speak the same legal language as the rest of the world based on mutual understanding. We further revised it in January 2020 to formally adopt the JIN modalities of court-to-court communication. So these modalities say that when I want to communicate with foreign court in other jurisdiction, we may use various modes like emails or letters or phone calls or conference calls. And these modalities contain those basic grounds for which modes to contact to the other court when it comes to court communication. And the specific mode can be agreed upon between these two courts. Next slide, please. Yes, thank you. So how does this work in reality, in real practice when I come back to my court? We have a designated judge for cross-border cooperation and coordination, and that is me, the CBCC judge. Let's examine the procedural flow chart shown here on the screen. And also the letter is too small, and I will tell you the flow chart from the beginning. This is the situation where a domestic insolvency practitioner requests cross-border cooperation. If a domestic insolvency practitioner needs to request cooperation from a foreign court, they first consult the judge presiding over the domestic proceedings. If deemed necessary, the judge presiding over the proceedings refers the matter to the CBCC judge. I then formally reach out to the foreign court to arrange the specific procedures. Once the procedures of cooperation are finalized between me and the foreign court, I notify our judge presiding over the specific rehabilitation or bankruptcy proceedings, who then carries out the cooperation in accordance with the agreed upon terms. Next slide, please. So conversely, if an inquiry originates from a foreign court or foreign representative regarding domestic proceedings, the CBCC judge receives and reviews the inquiry. I acknowledge receipt to the foreign counterpart and assign the inquiry to the appropriate judge presiding over specific rehabilitation or bankruptcy proceedings in my court. The judge presiding over the proceedings examines the matter, reports back on how it should be handled, and I then discuss the detailed procedures with the foreign court to reach a final arrangement. The actual cooperation is carried out by judge presiding over specific rehabilitation, bankruptcy proceedings, and this process is conducted in collaboration with the CBCC judge. So next slide, please. So this structured point of contact mechanism ensures that communication is streamlined, secure, and highly efficient. To further solidify these relationships, we actively pursue memorandums of understanding, such as the MOU signed between the Seoul Bankruptcy Court and the United States Bankruptcy Court for the Southern District of New York and the Supreme Court of Singapore. And I understand that the Supreme Court of Indonesia will enter the MOU with the Supreme Court of Singapore in this upcoming May. So congratulations to signing that MOU. And next slide, please. The most recent example of our court-to-court communication is the successful coordination with the U.S. Bankruptcy Court for the District of Delaware, which began last October and continues to this day. In this case, a South Korean individual who managed virtual assets entrusted by investors on a US-based cryptocurrency exchange faced a crisis when the exchange entered reorganization proceedings in the US Bankruptcy Court for the District of Delaware. I'm going to call it a Delaware court, leading to a freeze on all account transactions. While the individual was subsequently convicted of fraud in Korea, a separate individual rehabilitation proceedings were commenced in the Seoul Bankruptcy Court. In October last year, the chief judge of the Seoul Bankruptcy Court sent a formal letter via email, the formal letter with his signature on it via email as an attachment to the chief judge of the Delaware Court. This letter informed the Delaware Court of the Korean proceedings and drew attention to matters requiring mutual cooperation, such as the recovery of assets from the exchange. The chief judge of the Delaware Court responded immediately with a formal letter via email expressing a clear intent to cooperate. Under this established framework of coordination, the Rehabilitation Commissioner of the Korean proceeding has since filed for recognition, which is a specific action, the recognition under Chapter 15 of the United States Bankruptcy Code in the Delaware Court, and the recognition was granted within a short period of time. So go to next slide, please. This kind of ongoing cooperation is going on through the judicial exchanges. Our commitment to cross-border judicial and professional engagement is continuous. Just in recent years, we have engaged with jurisdictions and organizations ranging from Singapore and New York to Cambodia, the JIN in Sao Paulo, and the International Women's Insolvency and Restructuring Confederation and East Asian Insolvency Symposium. So we're nearly there for the conclusion. Next slide, please. So looking toward the future, the successful management of global distress requires the harmonization of civil law jurisdictions with common law jurisdictions under the UNCITRAL model law. We jump to the next slide. Yes, we are deeply encouraged to walk this path alongside with our colleagues in the Republic of Indonesia, noting the vital roles of the judges, professors, professionals, and experts supporting the legislation in this path. The world of law is no longer confined by borders, as we see in cross-border insolvency. I encourage you to look beyond your textbooks and embrace a global perspective. Your curiosity and open-mindedness will drive the innovation that the legal world needs. And I prepared something in Indonesian language as well, and I'm afraid if I might make a mistake in the pronunciation. Kalian adalah masa depan Indonesia. Thank you. And semangat terus. Yeah, fighting. Yeah. Cheers. By establishing specialized insolvency course, that is the one pillar. Second pillar is maintaining transparent procedural guidelines, which supplements the DRBA, the Act, and fostering direct court-to-court communication. This is the third pillar. So the Seoul Bankruptcy Court has contributed to enhancing predictability and transparency, minimizing unnecessary procedural costs, and maximizing overall efficiency in cross-border insolvency matters. Our laws may look different on paper, but our results speak the same language as the global standard. Next slide, please. For continuous updates on our jurisprudence and judicial exchanges, I invite you to read the Insolvency News in Seoul, accessible via the pink link on the main page of the Seoul Bankruptcy Court website. The final slide, please. So we delved into the legal technicalities, and you may have noticed the visual theme of my presentation today. I have intentionally chosen designs featuring traditional Korean architectural patterns and the Korean pine tree. The patterns you see on these slides are inspired by traditional Korean lattice, just as these patterns are delicately interwoven to create a sturdy structure. Cross-border insolvency requires the seamless interweaving of different legal systems. In Korea, the pine tree is much more than just a part of our landscape. It is a profound symbol of resilience, integrity, and endurance. It stays green and steadfast even in the harshest winters. As you look at these slides, I hope you feel the spirit of resilience that guides our judicial practice. And hopefully, like the pine tree, our judicial cooperation will remain evergreen and last for a very long time. Thank you very much for your time and attention today. You're welcome to reach out to me via the contact details provided on this final slide. And terima kasih, syukron kasiran. Thank you.
Let's again give a big hands to Madam Yu. Thank you.
Thank you.
Well, as I mentioned earlier, actually, we would like to listen to Professor Atkins about his experiences in communicating these very basic issues with Ministry of Law and the Mahkamah Agung. Unfortunately, due to his tight schedule, he has to leave very early, so we do not have the chance to ask questions to him. But if I can make a short summary, I think Professor Atkins has already shared with us how important it is for a country like Indonesia to adopt insolvency law. That's number one. Number two, it's very important to establish a good working relationship with other jurisdictions. And in order to do that, we have to have a means to have a good working relationship with them. So Professor Atkins says that his recommendation is to adopt the uncitral law as a means to do that. Now, the question that maybe later on, Pa Arya can share his understanding on this. The question for Indonesia is, how we are going to adopt the UNCITRAL law and how we would adjust ourselves, I mean our legal system, to that UNCITRAL law. What would be the parameters that we have to carefully take care of in order not to jeopardize our own legal system? I think, Pak Arya, this is one basic question, and I believe the students excuse me, have interest to do to know that further. Number two, we appreciate, Madam Yu, you have explained to us how Korea adopts UNCITRAL law and how you established a very special court for that. I think we learned a lot from your presentation. Actually, in line with what Professor Atkins has already presented, what are the externalities that Korea is facing in adopting UNCITRAL law? Sorry, sometimes this terminology is not so familiar to me, but I think we are the Indonesian. As an Indonesian, we are very much interested to know what are the externalities. Well, by externalities, I mean problems creating outside of the Korean border, affecting the business communities in Korea. Indonesia is very interested to also to know your experience for that, so that we could have a smooth flows of work in adopting UNCITRAL law, number one. Number two, how to adjust the substance of UNCITRAL law into the domestic Indonesian legal system. Perhaps before I turn over to Pak Arya, maybe I would give you a chance first to address this issue before we invite questions from the floor.
Yes, of course. Thank you. Yes, I think Indonesia will have the similar considerations about the challenges they're confronting because it is from a civil law jurisdiction. And personally believe that UNCITRAL model law is not a matter of common law or civil law. The language is simple and clear. It gives automatic legal effects to enhance the predictability and so on. But for some reason, Korea had to make some changes that I mentioned before in the DRBA. And I think that's because I believe every legal instrument has to be construed with its cultural context, especially their views to the role of the judiciary as well. And it used to be like this. Korea depends on the final decision by the court, which is the Korean court. So when it comes to dispute resolution, Korean people tend to think and depend a lot on court's final decision. So that has to be the reason why the basis for the specific recognition order and then the relief order separately adopted in Korean law, which is DRBA. But in practice, we do not have a case denying recognition. Before denying recognition, actually, I wanted to explain something about a specific article in the DRBA that there are some requirements to make dismissal from the court that are like, if the party does not make prepayment for the procedural process, then that will be number one reason or ground for the order of dismissal. And the second one is if it is against the public policy of Korea. But some people might say that public policy is a really large hurdle to pass because it blocks the recognition order to be brought into the world. However, because the case is that kind of recognition denial has never happened. And the reason is this: before going to recognition order, we issue a kind of order for supplemental documents to be brought to the tribunal. Like for example, let me tell you about the Russian court case, which was the recent one. We held a court hearing in a short period of time and asked the parties how these rehabilitation procedures are done before Russian court. And we listened to what they explain about the procedures they experience in the Russian court. And we requested some legal references and direct articles that work as the basis of those procedures in Russia. And of course, all the relevant exhibits like documents related to it. But these didn't take so much time because we specified what documents we needed in a short period of time, and the parties submitted them in a short period of time. And after a quick review of those documents, we granted a quick recognition order, and also with that, simultaneously, a relief order. In this kind of system, so let me summarize, the DRBA itself reflects the Korean people's cultural context that the court has to exercise its discretion as to issuing the recognition order and the relief order. But in practice, considering the best international cross-border insolvency practice, we just simultaneously issue the recognition order and the relief order at the same time in order to avoid delay. So in this kind of manner, and also with the procedural guideline, which incorporates the gene guidelines and the gene modalities, which is widely accepted in other jurisdictions, which has the entirety of the UNCITRAL model law in their national law, we work as the same result we intend to achieve, and we are actually achieving the same result as those countries. So in this kind of sense, we are just speaking the same language, I believe, when it comes to the cross-border insolvency practice.
Well,
Thank
thank you.
you.
Very good explanation. So in other words, you have established a very conducive framework touching two areas. One, the court, okay? I mean, the court involving the Korean legal systems. And the other one is linking the Korean court to other countries' courts. I think these are very important because we want to know so that we could follow that example perhaps. Now, without further ado, let me ask for Pak Arya to explain to us the discussion between Professor Atkins, yourself, Mahkamah Agung, and Department Hukum dan HAM in this area. Are we going to have a new law on bankruptcy law, or are we going to revise the old one?
Thank you, Pak Normin, as our moderator this afternoon. So basically, in short answer to that question is yes. We have been longing for new, well, I cannot say new, amendment of the bankruptcy law since 2020. Yesterday, the Director of Legislation, Ministry of Law, already mentioned that the cross-ministerial agency committee that discussed the amendment of bankruptcy law now in its sixth anniversary, 6 year of its anniversary. So it has been rolling out since 2020. The demand is there, the willingness is there, but I must say that the movement is very slow. They're very slow. Right now, the two most important topic that is being discussed is first this chapter, cross-border insolvency, which was not included in the 2020 draft, but thank God it was later agreed to be included in 2025 draft. And then the other issue that has been pending for so long is the protection of state-owned enterprise. It was not serious issue before 2025, but starting 2025, after the inception of Danantara, the demand to protect state-owned enterprise increased a lot. So we've seen the current bill makes it almost impossible to file bankruptcy or suspension of payment against a state-owned company. There is a draft that says that you must have at least 100 billion rupiah receivable against a state-owned company in order to file bankruptcy against them. And also the most recent draft require that government may be able to withdraw the petition. If there is ongoing petition from third party, from the creditors, the government will have the authority to take the litigation outside the court and settle it outside the court. But I don't know what will be defined as settle it outside the court, whether the government will pay everything or I don't know. But that's very serious issue right now. So it's been discussed for the past 6 months. Yeah. But I must say that we are living in the era where where the demand for legal reform is to achieve legal certainty. So we are measured by international community on the basis of to what extent we are comply with the international best practice. Why government finally agree to roll out the amendment of bankruptcy law is because, like it or not, is because of the driving force behind the ease of doing business. Yeah, and now the business ready report. Yeah, the business report, be ready report explicitly require that country must have a sufficient legal framework when it comes to cross-border insolvency. Now Indonesia is zero on that. So if we are not able to deliver the cross-border insolvency regime within our law, so the rank will still low. So will not be regarded as competitive jurisdiction. So it will lead to the country which is less attractive in the region, because we know that Malaysia has just last year, end of July, they adopt cross-border insolvency after we discussed that for so long. So that is the reason. And also, we also admit that, so like I say earlier, so we are, like it or not, dictated by international best practice. Why? Because investors coming from abroad, basically. If we only care about investors coming from inside, from domestic, we may not need to pay attention to international best practice. But the issue is we want to attract investor as much as possible. So that is why the urgency to have the legal framework meets the international best practice is very urgent, very urgent. So for example, Indonesia take its legal framework in insolvency on the basis of the old faillissement vooronderneming, right? From the Dutch, right? The Dutch have two procedures, faillissement and suspense van betaling, which is bankruptcy and suspension of payment. That's from the Dutch. They have that since 1870, if I'm not mistaken, Pak Ricardo, 1870. We adopt that in 1905. Yeah. And then right now, the Dutch already no longer have only two. They have now 4 procedures. In addition to faillissement, suspension payment, they only have skuldsanering for natural person, which is debt pemotongan utang, debt discount for natural person, for individual. And then during pandemic, the Dutch government issue another law called WHOA, Wet Homologasi Onderhands Akkoord. Which is basically an official agreement that can be. So basically, you can agree to solve your debt outside the court and go to court to get approval by the court. So it will be bind. It will be bind. So that's just to illustrate how Indonesia is left behind to our own patron, which is the Dutch here. So I think when we turn again to how government will address the adoption of cross-border insolvency model law, the plan is to include that as one of the chapter in the our bankruptcy law. So that's going to be, I think, I don't know which chapter is that, but it's going to be inside the bankruptcy law, so not as a separate law. So we have made very significant progress right now. So initial draft was there is a strong level of protectiveness. They want to only to provide recognition only to the country that recognize of the judgment, only recognize of judgment. So, but of course, in unilateral model law, such recognition clause is not required because, for example, Singapore has been recognizing our judgment without ever requiring reciprocity. So that's finally agreed that we won't be requiring reciprocity. That's the first. The second is which court is going to be have the authority to hear the recognition and assistance. There was a discussion that it should be at the Supreme Court because Supreme Court wants to control the quality of the recognition process because learning from international arbitration award, recognition of the Supreme Court feels not really satisfied with how lower court implement their authority in international arbitration award. They want more certainty, so the idea was to have it in the Supreme Court. That was circulated in the last year draft. But later it was discussed that if the Supreme Court is the front door of recognition assistance, meaning that the Supreme Court will need to change itself from judex juris into judex facti because they got to have hearing there. So later it was agreed that it's going to be in central Jakarta. And then there are several more detailed issue on how to operate concurrent dispute on concurrent proceeding, which is, I don't think we have the answers right now, but I suspect that we will learn by doing. Yeah, I think Judge Yu will be able to tell us what to do when it comes to concurrent proceeding, two separate proceeding in country and outside the country. What should we do about that? Because nobody have the answer for that. And why we have this visit of experts from South Korea and also from Japan. Actually, yesterday the session with Ministry of Law also featuring resource person from Japan because we want to learn how civil law jurisdiction integrate this model law to their jurisdiction because we have same features, which is civil law. Because there is a myth before this mission, which says that, well, it's a common law thing, so that cannot be easily adopted to civil law jurisdiction, but apparently not. I think because it was explained that the model law is only a principle that you need to adjust to be effective in your court. So I think we are on the right track, but we need more pressure from academics, practitioner to move even faster because it's in its 6th year already. Thank you, Pak.
Thank you, Pak Ari, for the explanation. So in other words, Indonesia has reached the highest learning curve towards acceptance. That's a good explanation, and we have been talking about this for years actually. So if we are going to have the new ones, then we have a lot of examples to follow, as just explained by Madam Yu, how Korea addressed the situation. I understand that there is an audience through Zoom, right? Shall we give the first opportunity to ask questions from the Zoom, or is there any facilities for? No? Okay. So in other words, thank you for our colleagues participating through the Zoom system. Pak, can you share your view, or do you want to ask questions to Madam Yu? Okay.
Thank you, Pak, and thank you for Judge Yu for your explanation. Yeah, we understand. I think we can still see, I mean, the debate between the common law and civil law, even though it is not a very principled one in trying to put this model work. But I think I'm going to ask your experience. Yeah. You stated about fostering the communication between courts, right? So, I mean, the way for that is, of course, must be based on the models, the principles, which is stated in the Jentera. Okay. According to Article 2 of the Jentera, it is stated that there is a main proceeding and non-main proceeding. And the main proceeding is based on the center of main interest, and the non-main proceeding is based on the establishment. Okay. So if it comes to the question of Pak Ari, then there's a concurrent proceeding. Okay. But say that the non-main proceeding assumed to be in Korea, but Korea say that according to the Korean law, the competency is based on the what we call that, the place of incorporation. For example, like us is the competency of the court is based on the place of incorporation. It is very clear in our Article 3, paragraph 5 of bankruptcy law. So how do you communicate with this kind of problems? That's my first question. My second question is, there is the way, according to Article 15, there is the way for the decision of foreign judgment will be submitted to the country where the decision will be what we call that, executed. All right. So I think they will provide the document that has been registered. Okay. So if according to Article 16, paragraph 3, if they cannot prove that the document has been put or registered, then the court can presume, okay, that the document is original. And if they cannot prove that the debtor registered, the debtor commie, yeah, then the court can prove, can assume that registered place of the debtor is the commie. So how is the Korean, court can communicate with this kind of difference, of problems? Because I read in some other journals, yeah, the problem of deciding which one is the main proceeding or non-proceeding is still there, even though I don't see that as a big problem. But what we are going to hear from you is how Korean court can communicate this, because we need as well the very clean point for our court to communicate, since our court is based on the system, a civil law case, like your country. So how do you solve that? That's a question. Thank you.
Oh, yeah, thank you. So let me clarify whether I understood your question correctly. So for the second question, the clause of assumption, that is that article is in Indonesian law.
No, that's Indonesian law, Article 16.
You mean UNCITRAL? Yes. Well, to answer to your question, first of all, of all those cross-border insolvency cases, I wonder why I didn't see such issues come to the surface. I don't know why, but maybe those cases did not involve the issue of those questions, maybe until now, but maybe in the future that may arise to.
Oh, you mean in your experience, you haven't got
that kind of issues never happened yet. I mean, to the second question that you asked me, But to generally answer to your questions, let me introduce you Article 639 of the DRBA, which is Korean law. I told you earlier in abstract that there is no officially, the first step of the use of the word foreign main proceedings in the law. However, when we go deeply into it, through the layer of the court's decision by discretion, we can decide whether this proceeding is a foreign main proceeding or not. Let me tell you the wording of those clauses. First of all, it can be the answer to Arya's question as well. It is about the concurrent proceedings. Article 639, paragraph 1. When an application is filed for recognizing multiple international insolvency proceedings for the same debtor, the court shall hold a joint hearing thereon. And the paragraph 2 of that Article 639 is when recognition is granted for multiple cross-border insolvency proceedings for the same debtor, the court may decide on which are to be a main foreign insolvency proceeding, taking into account the location of the debtor's principal place of business and measures taken to protect creditors. In this regard, although the word komi is not in the law wording itself, all the judges in this regard considers the center of main interest. So in that way, although it is not written on the cover of the language of the law, we all consider when it comes to concurrent proceedings, whether the court has to decide by its discretion which one is the main foreign insolvency proceedings. And in that way, we have all the premise that we have to consider the komi in the word of the debtor's principal place of business in this concept.
So if I can understand that if there's a concurrent proceeding like that, and say that there is an assumption from the other foreign judgment that Korean is non-main proceeding, then what you do is that your court will communicate with the court of the country where the decision was made, and then this court will decide which one is the main proceeding. Is that?
But I want to ask the premise that you gave to me before you reach the conclusion in your question. Could you repeat the first part of what you just said?
Yeah, because concurrent proceeding will very closely related to the consequences. Because what? Because according to the model, if the main proceeding will be based on center of main interest. Okay, so that's the way for international idea to avoid the fact that the company was registered or established in the Cayman Island, all right, which is only the place of registration, and then but registered in Singapore and play the business in Singapore. It means that the company will be in Singapore. In these cases, they presume that the main proceeding is outside, and it is still being tried. All right. At the same time, the debtor in your country is also filing bankruptcy, right? So because they thought or they think that the debtor in your country is non-main proceeding, so direct consequences of that, the debtor in Korea and South Korea must stay. Okay, must stay because they thought that it is Korea is non-main proceeding. So to your answer, what your court do for that is the court communicate with the foreign court and then decide which country should be the main proceeding. Is that?
Yeah, that is correct. But I want to put another thing with that. As I told you about the gene guidelines and gene protocols, we can communicate with the court. Yes, relevant to that kind of proceedings. And we are gonna coordinate about the concurrent proceedings and parallel proceedings in the manner. We sometimes hold a joint conference call and we have all those communications from court to court. So by means of that, I don't think, let me further check whether
Yeah.
I remember the specific instance or not, but I don't believe that came to surface as a kind of conflict between the two proceedings.
But in the journal, I think that's one of the I mean the case that in many places happens.
Mhm.
So I'm not I don't know Korean law, but
Mhm.
I once read that
Mhm.
the base of competency in your in your law is the establishment of the place of establishment of the debtor, right? I
Mhm.
think it's quite the same with us.
Mhm.
So if the place of establishment of the debtor is in Korea, of course, Korea will think that the main proceeding will be in Korea.
Mhm.
So the other one is not based on the place of incorporation. The other one based on center of main interest. So when it comes to the concurrent proceeding,
Mhm.
yeah, how is your court can communicate? Whether do you think that your court will just put aside
Mhm.
the law stating that the place of the main proceeding must be based on the place of establishment,
Mhm.
or you just follow that it is based on the center of an interest, since you have adopted the model.
Mhm. Okay, now I get it. I think it would be correct and better to answer to your question after I go through all those 36 cases that was decided by my court, and I will get back to you via ARIA.
Yeah, because I think as I think we met yesterday, right? Because as I told you about our recent experience about Penn Brothers cases,
Mhm.
okay,
Mhm.
which is it was registered in the middle of May,
Uh-huh.
yeah, but filed by other creditors, by creditors.
Uh-huh.
We need technically 20 days for deciding that, and suddenly this debtor fly to Singapore
Uh-huh.
and file it in Singapore voluntarily. They can just get that only 1 day, and then after that it was moratorium in Singapore.
Uh-huh.
And then Singapore administrator come to Indonesia, say to the court, okay, court, there has been decision of Singapore, and you must stay the case.
Mhm.
So even though our court does not follow that, they just dismiss the case based on that the petition is not simple. But again, my question is isn't it the question of this concurrent is which one is the main proceeding? So if it can be proved that Indonesia is the main proceeding, Singapore cannot start it.
Mhm.
Yeah, they must stay saying that it is tried in Indonesia. So this sort of the question that we need, the experience of civil law countries, how can you communicate? Because I agree that fostering is one of the point for us to to exercise the same or the similar point. Thank you.
Thank you. Yeah. Thank you.
I think you may continue your discussion later on. Yeah. Are there any questions from the floor? Yes.
Hi, thank you. Opportunity. Hi, Madam Yu. I just want to ask about the public policy ground for refusing recognition. I mean, I want to ask you about your experience in Korea, because you mentioned there's a 36 plus cases since the inception. And I don't know whether there are a lot of objection based on the public policy ground to refuse the recognition, or basically erode the recognition, because I was involved in some of the Chapter 15 cases, and I know involving Indonesia, and there are several cases where there are some parties who try to object the petition for recognition, and yeah, and then there is also a lot of case law and expert being brought into from the commies law, basically, so that the judge will need to decide whether it is against US public policy, or in their case, Korean public policy. And if so, how is your law regulated? Whether the judge decision is final and binding, or it still can be appealed by the objecting party?
Ah, you mean the appeal process?
Yes,
After the recognition,
yeah,
also
or
the.
recognition, or the refusal of the recognition,
Uh-huh.
or recognition but with the erosion, because sometimes with a limitation, because sometimes the objecting party not always ask for full refusal, but only partial on certain.
Ah,
And also
yes, yes.
from the 36 plus cases that you mentioned, whether the foreign proceedings relating to bankruptcy
Mhm.
or restructuring, like the Chapter 11
Mhm.
type of the US or bankruptcy, or liquidation. Because there are several. I mean, foreign proceedings can be many, right? But I think most of the time there's only like one is bankruptcy liquidation and restructuring or. Okay.
Okay,
Thank you.
thank you. So,
Think,
Mhm.
if I may,
yes, of course,
if
please.
I may
Clarify.
rephrase,
Rephrase. Uh-huh.
this,
Uh-huh.
how does Korea handle the issues of public policies involving insolvency?
Uh-huh.
Maybe straightforward question, right?
Yeah.
Because you see, in this country and
Mhm.
maybe in other countries,
Mhm.
public policy is a very important thing to follow.
Mhm.
And sometimes public policy is the ground for criminalization.
Mhm.
At least, according to our corruption law,
Mhm.
public policy is used to criminalize, quote unquote. So I think his question is, how do you handle the issue of public policy involving insolvency in Korea, right, Pak? Kira-kira begitu?
Recognition.
Yes.
Mm-hmm.
I think you can reject recognition.
Uh-huh. Yes, yes. Yes, yes.
Can be very, very widely, very broad.
Yes. Very good question, I think. Thank you. Yeah, I talked about the Russian courts foreign proceeding case, right? What we did there was there were some creditors from Korea in the Russian proceedings that have sometimes collateral or sometimes different kinds of claims against the debtor. So we wanted to see from the document from associated with the procedures in the Russian court that the Korean creditors were given the due process and the opportunities to reflect their claims in their procedure, and that protection given from the Russian proceedings are equivalent to the grade that is given in the Korean proceedings if it were processed as the Korean proceedings. So to see that, we asked for we call it a list of creditors in the proceedings of rehabilitation or bankruptcy in Russia. And there we see the list of the names of the creditors and their original amount of claims and how much percentage of that claim will be finally fulfilled according to the plan that was finally concluded in that proceedings. So after checking that those documents and compared it to what we routinely do and normally and reasonably do in our Korean proceedings, we decided that those creditors are well protected in those proceedings, and that's not against the public policy of the Korean public policy. So in that standard, we view other countries' foreign proceedings. Maybe this is the answer to your question first, and the other one was the appeal, right? Yes, we are the first instance court. The Seoul Bankruptcy Court is the first instance court that is specializing in insolvency. And then there is the second instance court, which is Seoul High Court. That is a court for appealed cases. There, we do not have insolvency only oriented second instance court. There isn't any, but there is a commercial division, which is called commercial and enterprise related claims and cases. And there, the high court judges composed of 3-judge panel, they see the appealed cases, and that includes the appeal to the recognition decision, which is an order. So in that sense, some will the parties are given another opportunity to argue against the recognition order, and that can go to the Supreme Court after that. So we have 3-instance system even to the recognition order. But usually there aren't many appealed cases, but there are some. So yeah, that will be the answer to your question, maybe. Thank you.
Is there any other question? By the way, Pak Arya, until what time do you stay here? Any other question from the floor? Yes, Pak Swandi.
Yeah, I understand that the Supreme Court of Indonesia is like drafting some kind of MOU between the Supreme Court of Indonesia and Supreme Court of Singapore, as also Judge Yo mentioned. Maybe I will direct this question to Mr. Arya. Maybe you can give us some preview of what is the content of the MOU. Is it some kind of mutual recognition, or is just a court-to-court communication? Maybe you can give us some preview, because once the MOU is signed, maybe at the end of this month, ASEAN Law Association will do some kind of, a socialization to the stakeholders in Indonesia. This is the first question. The second question is that, as my colleagues Ricardo has mentioned, there's a case of Penn Brothers. The registration of the suspension of payment, or PKPU, some kind of moratorium has started in Jakarta Commercial Court. But since it was filed by creditor, it will take like 20 days to trial the case before the court will decide whether to grant the PKPU or to reject the PKPU. And like 1 week after the filing from creditor, the debtor voluntarily registered a voluntary moratorium in Singapore. And since it's an voluntary application, it's like 1 times 24 hours granting by Singapore court. Maybe in these situations, I think the Singapore court must add one more requirement by there is requirement saying that the debtor must also stating that there's any other lawsuits or legal applications has been against the debtor. Because if there is no information going to the Singapore court, of course Singapore court doesn't have the information that any other proceeding has been lodged against the debtor. So maybe this is related also to the MOU from between Indonesia Supreme Court and the Singapore Supreme Court, that they have to add the requirement saying that the application to the Supreme Court or to the not the Supreme Court, the application to the commercial court must also disclose any other proceeding in any other jurisdiction where has been started. So the jurisdiction where the applications or petition is lodged in, they have all the informations relating to the petitions lodged in. Like in Singapore, they have to put in the requirement that the debtor must come clean and also should disclose any other applications or petition which has been filed against the debtor. Okay, maybe Mr. Arya, you can first give us some preview about what is the content of the MOU. Thank you.
Thank you, Swandi. It's not official yet, but generally the MOU content will follow the JIN protocol, ya, JIN protocol on court-to-court communication, ya. Judicial insolvency. JIN is not JIN as apa makhluk halus, itu bukan. JIN is Judicial Insolvency Network, ya. This is a network that regularly I think I don't know, is the network consists of judges and also practitioners. They meet regularly and they set standards that can be used for cross-border transaction or cross-border insolvency or restructuring, like that. So basically, it agrees that both Indonesia and Singapore will enable that the judge from Singapore can contact directly point of liaison in the Singapore court, and or alternate point of liaison whenever they need information regarding insolvency. The communication may range from making inquiry about certain case, making inquiry about the applicability of the law, or checking basically anything, any necessary, and court to court communication. And they also agreed a protocol how to communicate, whether via email, whether via telephone or video conference. It is as I understood, it is enabled by this MOU. And then also because this is ASEAN, because basically the MOU is developed under Council of ASEAN Chief Justices Network. So after this, the CACJ will also issue a model framework for court-to-court communication for ASEAN judiciary. So the same document will be published among ASEAN Chief Justices so that other interested ASEAN judiciary will be able to adopt that and establish MOU with any jurisdiction that they wish to. The plan is to have a multilateral memorandum. So the first step is going to be bilateral, Indonesia and Singapore. And then next step probably we will have multilateral memorandum with any other ASEAN jurisdiction that interest of having this MOU. Probably the next will be Indonesia, Singapore, Malaysia, and Brunei probably, or probably Philippines. That's the 5 possible jurisdiction that may join the multilateral MOU. But in the other side, and also then there is a protocol to publish the name of point of liaison and alternate point of liaison in the website of Council of ASEAN Chief Justices. So all ASEAN judiciary knows that who's to contact when it comes to ASEAN judiciary. So that's the plan. So that is in the MOU.
There is no in whatsoever the commitment for reciprocal communication.
No,
only communication.
Only communication. So because the MOU itself put itself as in a very soft tone, it says that this is not agreement, this is not treaty, this will not in any way supersede any law. So basically setting a protocol that we can contact, that this is how you contact, we will provide the contact. So that's the content of the MOU itself. But in implementation, of course, there needs to be, people will need to be briefed how to respond, how the standard of response, things like that. Because like Judge Yu says, she sent email to South New York Bankruptcy Court.
The Delaware?
Yes, Delaware. But there must be a protocol as of how long the Delaware court must respond. Otherwise, the inquiry will go unresponded. Things like that, just to make sure that you can send inquiry and the inquiry get responded in any means. So of course there will be need for adjustment, socialization in the future. Thank you.
Okay, Pak Arya, if I may pursue on this issue, it's gratifying to learn that Indonesia will be willing to discuss on a bilateral as well as on multilateral level. Next July, Pak Swandi, I think ALA will have a conference in Bangkok. And also concurrently with ALA's conference, there is a Chief Justice meeting. Pak Ari, do you think that this subject will be discussed in that international venue in sometime in July this year? Okay. Yeah.
In Singapore, then July will be 13th session meeting in Bangkok. I think they will ask all ASEAN judiciary to whether any other ASEAN judiciary will be adopting the model framework. If yes, they will sign them in the July meeting. If not,
wow, if it happens, that would be, I think, a good thing for this entire region. Maybe the last question before we conclude, from at the back. This would be the last question before we adjourn. Okay.
Thank you, moderator, for taking my question. Your Honor, Madam Jung, I want to ask a technical issue, perhaps. Yeah, in Korea, does Korea required skill in provision of English, given the fact that all proceeding of recognition in when it comes to decision of foreign country, mostly using foreign language.
Foreign language.
Yeah.
You mean the documents are written in foreign language?
Yeah.
Oh, so the parties, yeah, please proceed. Yeah.
Required a special skill for the judge in South Korea to be a judge at insolvency court.
You mean special skills or
to read the
judge
decision
to come? Yeah. Did you finish your question?
Yes,
or?
thank you.
Thank you very much. Thank you. Yeah. So yeah, first of all, we have to divide the insolvency judge and cross-border insolvency judges. Basically, in general, to become judges at the bankruptcy court, specialized bankruptcy court, there are no official requirements. Just you need to be judge. That's all, basically. And we have a rotation system. So for every 2 or 4 years, we move to other courts. And that is to ensure fairness among the judges and also to protect the decisions from personal attachment to a certain area or a certain field of area of law. But if you once become insolvency-oriented judge, then you will be given more chance to come back to the bankruptcy court because you know something about it and you have the skill set. While you worked there, you build some know-how and expertise. So that is one answer to that. But for the cross-border insolvency judge, I will introduce the system of our court. Our court has a lot of 3-judge panel that is called the division, the tribunal, and we name that like the panel 11, panel 12, panel 13, like that. And panel 19 of the Seoul Bankruptcy Court is designated as the cross-border insolvency division. And when the judges are judges come to the Seoul Bankruptcy Court at the season of the rotation, we submit our CV to the chief judge. And there is a committee deciding who would go to a certain division. There, we write our language skills and our expertise in private international law or insolvency law or cross-border issues. Then the chief judge and that committee decides what judge to go where. So in that sense, I wrote my English skills or other foreign language skills and also my degree in private international law and insolvency law, so on. Then I was chosen to go to that division, and that 3-judge panel of division is to decide the cases, actual cases, the recognition and the relief to cross-border insolvency issues. And among those 3 judges of dealing with those cases, one is designated as the CBCC judge, which is a cross-border cooperation and coordination judge. So in that sense, your expertise may be needed to be in that division and to become CBCC judge. But generally speaking, there is no hard or official requirement for it. So yeah, that may be the answer to your question, I guess. Yes. And to add, parties and the counsel for the parties have to submit the document with the official translation in Korean as well. That is kind of required by the civil procedure law, which can be adapted to this insolvency related cases. So in that sense, some will think that language skills that is not necessarily needed, but to check whether this translation is wrongfully done, I think language skills to a certain degree is needed for that judge to deal with insolvency, cross-border insolvency matters. And may I add a little bit about the MOU and the protocols? When it comes to MOUs, which was done between the Singapore Supreme Court and the U.S. Court, Bankruptcy Court in the District of Southern New York, we also did it in a very soft tone in order for the possibilities in the future, case by case, to agree upon between the courts, because each case needs different ways to cooperate. For example, some will prefer joint conference call, but some will prefer email correspondences like that. And we actually do not mention any deadline for inquiry to be given to the other court or to the reply to come to our court, because it may be, it may harm. It is really, we have to be cautious about the other judge's discretion to do what to do and when to do. So we do not mention those things, but we generally just based on mutual understanding and trust, we respond as soon as possible, or at least we send the email of acknowledgement to the inquiry as soon as possible. That is based on mutual understanding and trust. And these kind of trust or mutual understanding can be built in kind of exchanges in the global society, like gym meeting, or for example, I met the chief judge of the District of Delaware in one of the gym meetings that was held in Brazil, Sao Paulo last year. So we built a kind of network there. And that was the reason I could approach the Delaware jurisdiction's way of dealing with the cross-border issues. We get to know the other jurisdictions' way of dealing with the cases. And like that, the already built mutual understanding and the trust will lead to a facilitated cooperation and court-to-court communication. So it has to be a basic broad guideline and a basic soft law related MOUs. And based on that, each case can be taken case by case approach between the bilateral courts. Yeah, thank you.
Well, actually, it's very interesting to discuss this very issue, but unfortunately, time is of the essence that we have to adjourn our discussion. Before doing that, I think let us give a big hand to Madam. Now I turn the mic to the organizer.
Thank you, Dr. Normin. And please not to leave the floor because there will be a merchandise handover session. I would like to invite Mr. Swandi Halim to hand over merchandise from ASEAN Law Association to the speaker and the moderator. Okay, thank you, Mr. Swandi Halim. And I would like to invite Mr. Nicholas Muller to come forward and receive the merchandise. And also I would like to invite Dr. Arya to hand over merchandise from Jentera School of Law to the speaker, moderator, and Mr. Nicholas Muller. Yeah. Ladies and gentlemen, as we come to the end of this enlightening session, we would like to extend our deepest gratitude to our distinguished